We will go on the record in the matter 25 CM 76, State of Wisconsin versus Byron Benjamin. The state appears through District Attorney Kevin Schmidt in person, Daniel Chapman, Defense Counsel by video. Mr. Benjamin appears in person. We're set for a status conference. Mr. Chapman, can you please update the court?
Judge, the matter is resolved. We need a plea and sentencing. It'll be to a misdemeanor and a recommendation for costs.
What is the misdemeanor?
Criminal damage to property.
And for costs, is a restitution requested?
No, the victim no.
No. Mr. Chapman, I can set it if you wish. It's going to go into middle to late September. Is this something, did you go over all of the things you need to do with him? Because I could do the plea today if we're in victims' rights compliance.
I have not gone through a plea questionnaire with him, Judge, given I was planning to be there in person, but given that we have 12 or so hearings today, I didn't think we could. But if you wanted to do the hearing, I'm comfortable just doing it without the plea form. I'm sure Mr. Benjamin would appreciate that.
I'm comfortable as well if it's something like this, but are we in victims' rights compliance?
The victim doesn't know about sentencing, but she knows about the offer.
She didn't object to the offer? No, I think that would qualify as victims' rights compliance, but would you like to handle this matter today, Mr. Benjamin?
We could, yeah.
Okay, so I'm gonna go over a lot of questions with you. And I'll handle the plea, and you're comfortable with that?
Yes.
Your attorney is appearing by video, and you can see him over there on that big screen. If you have any questions or concerns and you need to speak with him, let me know, and I'll either have you go to our Zoom room and set you with a confidential breakout session, or I'll say, just go give him a call and we'll take a break in your hearing, okay?
Okay.
How old are you?
20.
Can you read, write, and you understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Anything that interferes with your ability to think and understand?
No.
Do you understand that you have certain constitutional rights, and by pleading guilty, you would be waiving those rights?
Yes.
You understand that you would have the right to a trial. You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand those rights that you would be giving up?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that there's an offer to plead to count 1, criminal damage to property, and a recommendation for costs? Is that your understanding?
Yes.
Do you understand the state would have to prove on or about Saturday, April 26, 2025, in Burnett County, Wisconsin, you intentionally caused damage to the physical property of another, a vehicle and a gate belonging to SS without that person's consent? Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you also understand that there is that recommendation, that joint recommendation to the court for costs only, but I don't have to follow it? Meaning, if I thought the facts of this case warrant it, I could sentence you all the way up to the maximum penalty?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, did you go over the facts alleged in that criminal complaint with your attorney? The facts of what happened that day and from the police report perspective? Did you
Yes.
go over that? And is that a yes?
Yes.
And for the most part, are those facts accurate? Are you admitting here today that you in fact did intentionally cause damage to a vehicle and a gate
Yes.
and you didn't have consent to do so?
No.
Mr. Chapman, may the court use the probable cause section along with the statements made by your client to find a factual basis?
As it relates to that charge, yes, Judge.
Has anyone made any threats or any promises to you, Mr. Benjamin, for you to plead guilty today?
No.
You're doing so freely, intelligently, and voluntarily?
Yes.
Has your attorney represented you competently? Meaning, has he done a good job?
Yes,
Has he looked into this matter and talked to you about it?
yes,
And are you satisfied with his services?
yes,
Any question for the court or for your attorney before I proceed?
no,
As to count 1, criminal damage to property, and a misdemeanor, how do you wish to plead?
guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. It will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think that sentence is appropriate. He and Brandon went back and paid the victim for the damages prior to this resolving. He has minimal criminal history, just one drunk driving in Minnesota, where he was also convicted of DC's same case though. So I think this is appropriate. Thank you.
Thank you. Mr. Chapman?
Judge, it was a birthday party. A lot of people were drunk. And as it relates to the domestic or the battery charge, I believe that would have been self-defense. Mr. Benjamin and his brother were leaving. They were upset. They punched some things as they were leaving.
Mr. Benjamin, anything you want to tell me? You don't have to, but it's your opportunity to let me know anything you want me to know.
No,
And are you currently employed?
yes,
Where do you work?
Grand Castillo and Hinckley,
Excellent. Now, do you work full-time,
part-time.
part-time? And you were able to go and pay that restitution, the money to fix those things?
Yes,
And you did that on your own?
yes,
All right. So, Mr. Benjamin, I'm prepared to give you a little bit of a break as it relates to court costs and fees, because you did the right thing before the court had to say, you have to do this thing. So I'm going to only assess $200. That's the mandatory DNA surcharge. I'm going to waive the rest of the court costs, which is $243. But I do need you to pay that within 30 days. Can you do that?
I can get that done.
Okay, because if you fail to pay that within 30 days, not only will the court enter a civil judgment against you, but I'll issue a warrant and you could sit up to 6 months in jail. So just make sure you have that paid within 30 days, okay?
Is there a way I could pay
Now,
here today?
yep, you can go right to the clerks when we're done and just get that taken care of.
Okay.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need you to go to the sheriff's department and provide your DNA. If they already have it, they'll say, we don't need it, but if they need it, they'll just swab you. With a case like this, you have the right to request it be expunged from the system through a written letter to the Department of Justice. You can ask your attorney about that. It's easy to do, okay?
Okay,
You can come get your sheet that you need to bring to the jail for the DNA, go out and pay your DNA surcharge, and you're good to go. Thank you. Colin Daniels. There you go.
All right, let's talk about that. The case of State of Wisconsin versus Byron Benjamin offered a rare glimpse of a court hearing that was both efficient and, dare I say, kind of heartening. In a system where plea deals often feel perfunctory, this one had real movement, restorative, personal, and refreshingly smooth. Judge Mogen once again showed why she's so respected on the bench: direct, informed, and always ready to offer a little grace when it's earned. Here's how it went down. The hearing started as a routine status conference, but quickly pivoted into a full plea and sentencing after the court confirmed that the victim had been notified of the agreement and did not object. Mr. Benjamin was facing 2 charges, one of which was dismissed and read in. The remaining charge, criminal damage to property, was resolved by plea, with a joint recommendation for costs only, thanks in large part to Mr. Benjamin having already paid restitution directly to the victim. That's right, before the hearing even happened, the damage to the vehicle and gate had already been made right. That's a rare and powerful step toward accountability. Judge Mogen walked Mr. Benjamin through every detail: his constitutional rights, the potential penalties, up to 9 months in jail or a $10,000 fine, and the meaning of his plea. Mr. Benjamin, age 20, was respectful and responsive. He confirmed that he understood what he was doing, admitted to the facts, and said he'd gone over everything with his attorney, Daniel Chapman. There was no waffling, no hedging, just a young man owning his actions and moving forward. Both attorneys kept it concise. The DA, Kevin Schmidt, explained that restitution had already been handled and noted Benjamin's minimal record. Chapman added that this had all happened at a birthday party, gone sideways, alcohol, bad judgment, some property damage. He even said one of the dismissed charges may have involved self-defense. But the real standout moment came when Judge Mogen, acknowledging Benjamin's initiative in paying for the damage before the court had to order it, decided to waive all court costs except the mandatory $200 DNA surcharge. That's not just leniency, that's a reward for responsibility. She gave him 30 days to pay, with a stern warning that if he missed the deadline, it would turn into a civil judgment and potentially even jail time. But Benjamin didn't hesitate. He asked if he could just pay it today. And the judge said, "Yep, head to the clerk's office." Just like that, the hearing wrapped with a brief reminder about DNA collection and appeal rights, and Benjamin left with a clear path forward. No hanging charges, a manageable fine, and if he keeps his record clean, possibly even a future expungement. It was a moment where justice felt real and human, not just bureaucratic. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.